A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Thank you so much for tuning in to another edition of Bearing Arms, Cam and Company. My name is Cam Edwards. It is great to have you with us. Going to do something a little special on today's program. Coming up on December the 2nd, the Supreme Court of the United States is going to be hearing a Second Amendment case for the first time since 2010. The Supreme Court is going to be hearing oral arguments in a case that implicates our right to keep and bear arms. So we're going to get into the nitty-gritty of this case, what it's all about, what the implications and what is at stake in this case. It's called New York State Rifle and Pistol Association versus New York City. And this case has been slowly making its way through the court system for a number of years. Something really interesting happened when this case got to the Supreme Court, however. So let's back up. What is this case all about? Well, the case challenges a New York City law for possessors of a New York City permit premises license. So if you are a handgun owner in New York City, you have to have one of two licenses. You can get your concealed carry license, but you're probably going to have to be politically connected. Based on the corruption that we've seen out of the licensing unit, you may have to pay some bribes in order to expedite your application and get it approved. It is very uncommon for a New Yorker to possess a carry license. There are about 30,000, I think less than that now, but about 30,000 concealed carry licenses in the city of more than 8 million people. More common, still very difficult to get, but more common is what's called a premises license. That permits you to keep that handgun in your home. It also permits you to take that handgun to one of 5 pre-approved ranges in New York City, and that's the only place that you can take your legally owned handgun. If you have family that live upstate and you want to take your gun so you can go plinking on their property, you can't. If you are a competitive shooter and you want to take your legally owned firearm out of New York City to go to a shooting competition, you can't. The only place that you can take that gun is to one of 5 pre-approved ranges in New York City. So that is the law that's being challenged. And New York City actually defended this law at trial court, where they won, by the way. And at the Second Circuit Court of Appeals, New York City still defended this law, and they won. And then when the Supreme Court decided that it was going to hear this case, New York City and gun control advocates around the country started flipping out. They have been trying desperately to avoid the Supreme Court hearing a Second Amendment case since the McDonald decision in 2012. There have been a couple of times over the past few years where gun control advocates have simply accepted a loss at the appellate court level rather than risk a nationwide precedent-setting decision by the U.S. Supreme Court. It's why we have concealed carry in Illinois, because the Seventh Circuit Court of Appeal ruled that the ban on carrying firearms in Illinois violated the right to keep and bear arms protected by the Second Amendment. And rather than risk the U.S. Supreme Court getting a right to carry case, gun control advocates prevailed on lawmakers in Illinois to simply not appeal the case, to accept the ruling of the Seventh Circuit. And that's why we have a shall issue right to carry law. Washington, D.C. did something similar. After D.C. passed their may issue concealed carry law, the Court of Appeals for the D.C. Circuit struck that down and said, no, it's discretionary. You're depriving the average resident of the ability to bear arms, and you can't do that. Because when the average citizen can't exercise a right, you're infringing on that right. Rather than risk the Supreme Court agreeing with the D.C. Circuit Court of Appeals, local lawmakers in Washington, D.C. acquiesced, and D.C. is now a shall issue concealed carry jurisdiction. In this particular case, New York City had won. So it wasn't up to them whether or not this case was going to get appealed. And when the Supreme Court heard or decided to agree to hear this challenge brought by the New York State Rifle and Pistol Association and several individual members, New York City, again, they didn't know what to do. So gun control advocates told them, hey, you know what, change the law. It's kind of a dumb law. It's kind of out there. There aren't many laws like this. In fact, there are no other laws like this on the books around the country that we can find. Rather than defend this law, which is going to be really difficult to do, go ahead and change it. And so that's what New York City did. They did change some aspects of this law. New York State changed aspects of state law. And the city began claiming that the Supreme Court shouldn't hear this case because the issue is now moot, meaning that there's no live question. Now, the attorney for the New York State Rifle and Pistol Association, former Solicitor General Paul Clement, he disagrees. He notes that there are still several live issues that they've already raised that were not addressed by the changes to New York City's law. And so far, the Supreme Court has not agreed to New York City's request to simply drop this case. However, the justices have said that during oral arguments on December the 2nd, that both sides should be prepared to argue the question of mootness as well as the merits of this case. So as we've been building towards this date with destiny at the Supreme Court, gun control groups and gun control advocates have continued to absolutely flip out over the possibility of the court taking this case and issuing an opinion. You actually had 5 Democrat senators, including Senator Kirsten Gillibrand from New York, who wrote they called it an amicus brief. They called it a friend of the court brief. As it turns out, it was not, because, well, for a couple of reasons. One, the senator who signed his name on this, Senator Sheldon Whitehouse, is not an attorney, and so therefore can't actually write a friend of the court brief and present it to the court. Secondly, the content of this supposed brief was anything but legalistic. It was a threat by these senators that if the court were to agree to hear this case, and if the court were to issue an opinion striking down this New York City law, and perhaps saying, well, we'll get into what the court might say here in just a little bit, but if they were to rule in favor of the Second Amendment in this case, that would indicate in the words of these senators that the health of the court was not well, and that the Senate might just need to step in under a Democratic president and pack the court, in essence. Add new anti-gun members to the Supreme Court to try to undo the quote-unquote damage that the court had done with the Heller and McDonald and perhaps the New York State Rifle and Pistol Association versus New York City decision. Why are gun control advocates freaking out so bad about a challenge to this New York City law that they admit is unusual and probably not likely to pass judicial muster? Why is it that this little law is causing so much consternation for gun control advocates? Well, it's because of what the court could say in its opinion. One of the challenges and one of the things that the plaintiffs are hoping to address, and one of the things that several justices on the Supreme Court have seemed very eager to address, is what they consider to be the abuse of the Heller and McDonald decisions by appellate courts around the country in order to uphold virtually every gun control law that's challenged. And the way that these appellate courts and these trial courts are doing that is by ruling that these gun laws should be viewed through the judicial lens of intermediate scrutiny, which is sort of the middle level of judicial review. And it's kind of vague and it's kind of fuzzy, and judges can basically say, all right, look, there's a compelling public interest for the government to pass these gun control laws. They're concerned about public safety. And so we give them broad leeway to put whatever laws they want to put on the books because they say it's for a valid a reason. Improve public safety. And it doesn't matter if it actually does or not, but that if that's the reasoning, then the law should stand. Plaintiffs in this case want the Supreme Court to issue their decision using a higher standard of judicial review, claiming that basically lower courts, again, have just misread or completely ignored what Heller and McDonald actually had to say about the right to keep and bear arms in order to pass these gun control laws. So there was a symposium online recently at the website SCOTUS blog. And our friend Dave Kopel, research director at the Independence Institute, and Randy Barnett, who is a professor of constitutional law at Georgetown University, had a piece in this symposium where they specifically talk about why the Supreme Court should address what they call, quote, lower court nullification of the Second Amendment. They say, talking about this case, that when the New York City travel ban was challenged, the Second Circuit Court of Appeals said that the ban probably didn't even implicate the Second Amendment. That New York City could tell legal gun owners, hey, you can't take your legally owned gun out of New York City, and that didn't implicate the right to keep and bear arms. That, again, is the type of egregious misreading of the existing case law that we've seen by these appellate courts around the country. As Copel and Barnett write, the Second Circuit is not the only court to pretend that obvious restrictions on the Second Amendment have nothing to do with the Second Amendment. The Supreme Court in Heller specifically instructed lower courts not to use the rational basis test in Second Amendment cases. Under the rational basis test, the most lenient standard of review in constitutional challenges to government actions, laws are almost automatically upheld. In the 2017 case Teixeira versus Alameda, the Ninth Circuit out west used the rational basis test to validate a California county's ban on all new gun stores. Yeah, this was a case that involved a county zoning change that did not explicitly ban new gun stores, but it said that no new gun stores could operate within, I think it was 700 yards of a residential area, 500 yards from a church or school or whatever. And basically there was no place in Alameda County where a gun store could operate and could open up. The Ninth Circuit, again, upheld that zoning prohibition. Basically said, there are other gun stores in the area, so, no harm, no foul. The Second Amendment, the Supreme Court did not agree to hear that challenge, unfortunately. But again, Professor Barnett and Dave Copel say the court now has the opportunity to address some of these egregious misreadings. When it comes specifically to the New York State Rifle and Pistol Association challenge, Barnett and Copel write, according to the Second Circuit, preventing practice with one's own firearm, because again, you can't take your gun except to one of 5 pre-approved ranges. The Second Circuit said, well, if you want to go shoot at a range outside New York City, just rent a gun, which is not the best way to train on your firearm. Barnett and Copel write, according to the Second Circuit, preventing practice with one's own firearm is such a minor inconvenience that the Second Amendment is not even an issue. For the sake of argument, they write, the Second Circuit did imagine that the travel ban should be reviewed under heightened scrutiny. Heightened scrutiny requires the court to carefully examine the evidence about the burdens and benefits of the challenge law. The burden of proof is on the government. The weakest form, they say, of heightened scrutiny is intermediate scrutiny, which is an easier standard than strict scrutiny. Strict scrutiny, they write, was originally created for judicial review of government discrimination based on race. Intermediate scrutiny was first used for review of government discrimination based on sex. The Second Circuit says that strict scrutiny never applies to the Second Amendment. Some federal courts elsewhere have said the same. So the Second Circuit reviewed the travel ban under intermediate scrutiny. Now, Barnett and Copel say that the Supreme Court supposedly has rules for what you have to look at when you're examining a case under intermediate scrutiny. They say that the government must provide substantial evidence, that the government must overcome rebuttal evidence, that the government must prove that its objective is achieved more effectively through the regulation than through other means. The government must consider substantially less burdensome alternatives. And Barnett and Copel say, when looking at this case, the Second Circuit just ignored all of those requirements. And that is, again, a commonality that we have seen from many courts around the country. So that's why gun control advocates are flipping out about this case, because it provides the Supreme Court with an opportunity to say, you know what, this is a real fundamental right that we're talking about here. And these gun laws that infringe on the rights of individuals to keep and bear arms are unconstitutional under a strict scrutiny reading of these particular ordinances. And if they explicitly state in their opinion that strict scrutiny is indeed the proper test when looking at the constitutionality of gun control laws, 2 things are going to happen. 1, some gun control laws are likely to be overturned. Two, courts are also going to continue to likely misread and misrepresent strict scrutiny in order to try to uphold gun control laws wherever possible. I mean, we should have no illusions to the contrary. Courts are going to keep trying to play their shenanigans that they've been doing with the Second Amendment since Heller and McDonald. But it will be much tougher for these courts to do so if the Supreme Court explicitly states that strict scrutiny is, in fact, the proper test when looking at the constitutionality of these gun control laws. Under strict scrutiny, the government has to basically ensure or provide evidence that the laws are narrowly tailored to achieve this public benefit, in this case, public safety. And that there are, it is the least restrictive means possible to achieve that public interest without implicating the individual rights of Americans. So if that's the case, then you can imagine a lot of these really broad gun control laws that are aimed at every legal gun owner in the hopes of entrapping some criminal somewhere are going to be tossed out because they are not narrowly tailored to achieve that public safety benefit. They are very broadly tailored to implicate the vast number of law-abiding legal gun owners. That's the concern for gun control advocates. But again, we still don't know that the court is actually going to issue an opinion in this case. They could hear arguments coming up next Monday and decide that, yeah, you know what, the case is in fact moot. And they could send the case back down to the lower courts. They could dismiss the case outright, which is what gun control advocates are hoping for. Or they could hear these arguments and agree with Paul Clement that, yeah, there are still some live issues here. Or they could also agree with the argument that, hey, you know what, even if New York City changed their law, they did so in order to avoid scrutiny by the Supreme Court. So what's to stop them from changing the law back as soon as the Supreme Court gets rid of this case? Go ahead and you can't trust New York City to do the right thing because they didn't change the law until the Supreme Court agreed to hear the case in the first place. That could be a persuasive argument as well for the justices. Now, on the off chance that the Supreme Court does dismiss this case or send it back down to the lower court, there are still several Second Amendment challenges that are sitting in conference right now that the Supreme Court has not decided to hear. They've not decided to toss. They're just hanging on to those cases. There's a lot of speculation about why that is happening. And one, I think, my personal favorite in terms of the theories is that the court is hanging on to these cases for a couple of reasons. One, that these cases may be the decision in New York City Rifle and Pistol Association versus New York City may implicate these cases. And so if they issue a decision in New York City or New York City Rifle and Pistol Association versus New York City, they can then look to these other cases and say, okay, now apply our guidance here to these other cases and send those cases back down to lower court. If, on the other hand, they decide not to proceed with this challenge to the New York City gun law, they have a couple of other cases in reserve that they could quickly bring up as another a case involving the right to keep and bear arms. A lot of these cases deal explicitly with the right to carry. The New York City case does not. It deals with the right to travel with a firearm, but not necessarily, depending on how you want to read the Second Amendment, the right to bear arms outside of the home. These other cases, Rogers versus Grewal is the one that I think has been sitting out there the longest. That is a challenge to to New Jersey's concealed carry laws, which again are May issue laws. And you already have courts of appeals around the country that have said, yeah, these May issue laws are unconstitutional. You've got other courts that have upheld these May issue laws, like in California, the Ninth Circuit in the Peruta case. So there's a split between the courts of appeals, which might make a right to carry case more appealing to the Supreme Court if they ultimately decide to kick this New York City case back down to the lower courts. So again, we will hear oral arguments next Monday. We won't hear them. We will be able to read written transcripts, but there are no recordings. I take that back. Sometimes there are recordings. There are no cameras in the courtroom, but we may actually get a chance to hear the oral arguments. There certainly will be written transcripts made available. Do not expect a decision by the Supreme Court to come down right away. It's possible that if there's some sort of unanimous agreement, that you could have a decision issued fairly quickly. But I think it is much more likely that we'll see a decision come out from the court regarding New York City and their gun law in probably the late spring, early summer of 2020. All right, so there you go. That is a primer on the New York State Rifle and Pistol Association versus New York City gun case. If you have any questions in addition to what I just laid out, feel free to shoot me an email, cam.edwards@bearingarms.com. And, of course, on Monday's Cam and Company, we will be talking quite a bit about what's happening at the Supreme Court. All right, let's get to today's armed citizen story, our good deed of the day. And, of course, our recidivist report. In fact, we should probably start there. I don't know what is going on at chicken joints around the country, but we have the story of the armed citizen at a Raising Cane's in Texas who put a stop to a assault a few days ago. And we got the bad story. A Church's Chicken shooting suspect in California, as it turns out, has a lengthy criminal history from KGTV in San Diego. The man accused of killing a Church's Chicken employee several weeks ago waived extradition in Tennessee. Albert Lee Blake, tracked down in Memphis last week. He's wanted for the murder of Maribel Ibanez. His fugitive from justice without a warrant case was dismissed by a judge, which means that San Diego authorities have to go to Tennessee to pick him up and bring him back to San Diego. He's facing 2 counts of attempted murder, accused of willfully and deliberating shooting Mario Rojas and Humberto Gerardo Cota at the restaurant as well. And as the San Diego TV station points out, this guy is well known to law enforcement in California. Criminal history dating back to the 1990s. 2016, he was charged with counts of manufacturing a controlled substance, possession of marijuana for sale, possession of a firearm by a convicted felon. Violated his probation earlier this year, but wasn't sent back to prison in California. He's also served time for felony domestic violence in 2002, burglary back in 1990. Now facing 25 years to life for the latest charges. And again, not only are California's gun control laws implicated in this crime, but California's treatment of convicted felons implicated in this as well, because the state has passed several initiatives and legislation over the last few years that lessen sentences for offenders, lets people out early, reduces the actually even in some cases, says we're not even going to charge for certain crimes anymore. I mean, we've seen that happen too with the DA in San Francisco saying not going to charge for certain crimes. And violent crime has not been going down in California over the last few years. It has been heading the wrong way, in part because of cases like Albert Lee Blake. On to our armed citizen story today. I got to tell you, I think this one might end up being a full story at Bearing Arms later today. Check out this headline. Miami man in van guns down AK-47 wielding robber because he didn't want to, quote, go out like a punk. That's right. This is CBS 4 in Miami. A 60-year-old man, Donovan Stewart, said that he was forced to shoot and kill a gunman who had broken into his van early Monday morning in an attempt to rob him of his jewelry. Said he was sleeping there in the van with his family. And he said the guy, quote, opened the door, pointed his AK-47. I reached around like this. I got my gun. That's how I did this to him. He said, I thought, you're going to kill me, so now I have to act quickly because I'm trained. He said, I have a security license. I have a state firearms license. I have a concealed weapons permit. I have a gun, and I'm a member of the NRA. The 60-year-old from Kingstown in Jamaica said, I'm not going to go out like a punk. I emptied my Glock into his chest. The man tried to get in my van while I was sleeping, and he was surprised to see what I did. He went on to say, quote, I'm going to defend my life and those I love. He said, my family is innocent, and just don't put an AK-47 in my face. I will not allow that to happen. He said, this guy also hijacked a woman in a van and was found with her car key. He robbed another woman at gunpoint. You want to come looking for trouble? Come to me, he said. I wouldn't do anything like this to anybody that picked the wrong person in this case. Meanwhile, Mike Vega with the Miami Police Department says right now, everything looks like this is a case of self-defense. The investigation is still going on. He says we need to put this all together and determine what happened. The police do confirm, by the way, that this suspect who was shot and killed was in fact involved, apparently, with some earlier crimes. According to CBS in Miami, a woman named Delilah Gator and her boyfriend told the local reporter there that the guy who was shot and killed was the same guy who terrorized her Saturday morning around 6 o'clock in the morning, robbed her at gunpoint of $600 in cash, her phone, and her car. She said he had a gun and he forced me to open my door. He told me to open, so I gave him my cash right away. She said, I feel very relieved now. This was a terrible thing to do to me. I was devastated. I was emotional. She said, this is crazy to rob this man. He has a family. And to do something like that while he was living in a van isn't right. The Miami police officer said police trying to determine if the unidentified suspect who was shot and killed had robbed other people. But again, according to one of the victims in this case, the answer is yes. So we'll keep our eyes on this case involving Donovan Stewart there in Miami, who says that he was forced to protect himself. And again, evidence sure looks like that was the case on Monday morning in his van. All right, on to our good deed of the day. Where am I looking? I'm looking here. Good deed of the day from Hartford, Connecticut, where Officer Jim Barnett is the Hartford City Hall Chief Security Officer. And according to Eyewitness News 3 in Hartford, he is a man on a mission to help the city's homeless. The military veteran said, as an NCO in the Army, we don't leave a man or woman behind. And while he is retired now, he keeps that motto in mind as he goes about his days there in Hartford. According to Eyewitness News 3, those who need guidance come to Barnett City Hall office for support. Sometimes they need a blanket or some socks. Other times they just need somebody to listen. He says if you don't have that connection with these guys out here on the street, they won't trust you. And he said it's taken years to earn their trust. He said they see what I'm really about. It's not this piece of material that I'm wearing on a regular basis. They look at me that I do care. Eyewitness News 3 talked to a gentleman named Joseph Sabinski, who is currently homeless in Hartford. Barnett is helping him until he can get to a shelter next month. Sabinski said he doesn't care where you're at in life. It's just a characteristic that you don't find much anymore. Barrett says he's been doing this for several years now and estimates between 2,000 and 3,000 people have come through his office seeking help and finding it since he began working there at City Hall 4 years ago. So in the right place, at the right time, willing and able to do the right thing. Officer Joseph Barrett there in Hartford, Connecticut. We thank you for your many, many good deeds. That is going to do it for this edition of Bearing Arms, Cam & Company. Thank you for being a part of the program today. We'll be back with one more program this week on the show tomorrow. Mark Walters from Armed America Radio is going to be with us. We will be taking off Thursday and Friday from the Bearing Arms, Cam & Company show, but you will get fresh content at bearingarms.com each and every day. Don't forget, you can subscribe to this program as a podcast at Apple Podcasts, Spotify, Stitcher, townhall.com podcasts. And you can also become a VIP member of Bearing Arms as well. If you go to bearingarms.com, you get exclusive content and commentary, and you get to support the segment of journalism that we do each and every day. Thanks for being a part of the program. Have a great day. We'll see you back here tomorrow.